Welcome to the DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the DWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 125 of the DWI Guy podcast. On today's episode, we are going to talk about something that is often taboo, and that is legal fees. Legal fees connected specifically with DWI cases, but for criminal defense charges generally. I think this is something that there is not adequate discussion about. It is often something that we remain hush-hush about, don't communicate about with other members of the bar. And so we are going to walk through what is a no-no, which is charging a clearly excessive fee, and what the rules of professional conduct define that as, what to consider in terms of setting a legal fee, and then how we can make sure that we are always trying to provide value to the public and making that kind of the primary focus of our practice. So to just go right after it, and actually before I dive in, on episode 64, we talked about why a client should hire you specifically. The name of that episode is Why Should I Hire You? And that, I think, is a really helpful episode to listen to prior to or along with today's episode. So I'd encourage anybody that is interested in today's content to go back and listen to episode number 64, Why Should I Hire You? But to dive right in terms of what is prohibited, that is charging a clearly excessive fee. Under the North Carolina Rules of Professional Conduct, Rule 1.5 is regarding legal fees, as well as other fees, but primarily legal fees. And so under 1.5a, a lawyer shall not make an agreement for charge or collect an illegal or clearly excessive fee, or charge or collect a clearly excessive amount for expenses. So relevant to our conversation today, the rules of professional conduct prohibit a lawyer from charging a clearly excessive fee for legal services. So what is a clearly excessive fee? What is something that is clearly excessive? Well, it's not defined specifically black and white, but there are a number of factors that are identified as being helpful in determining if a fee is clearly excessive. The comments to the rule state that this is a non-exclusive list. There are 8 items that are listed under Rule 1.5a regarding whether a fee is clearly excessive, 8 factors to consider. But the comments say that that's not an exclusive list of factors, that other things can be taken into account as well. But obviously, the factors that are listed, we pay particular attention to. And so I'm going to talk about 3 of those factors that I think are particularly relevant in the DWI setting. So Rule 1.5a(1) says that one of these factors in determining whether a fee is clearly excessive is the time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. This is really important, I think, when it comes to the DWI context within the world of criminal defense, because I think that anybody that's handled a DWI case, or particularly multiple DWI cases, can attest to is that this is a very complex, complicated area of law. It is a very intricate amount of rules that are related to this when it comes to the statutes, case law, administrative code, how this is played out in any particular jurisdiction. It requires a lot of time intensity to bring yourself up to a really high level of being a DWI defense lawyer. So education is important. The rule points that out, that a speeding ticket, the time and labor, the novelty of the questions involved is different than defending a DWI case. And that's not to say that a speeding ticket is just a simple thing. I think that a lot of us take for granted the impact that a bad outcome or a not clearly thought through outcome can have in terms of somebody's driving record, even in something that seems as simple as a speeding ticket. I've seen a lot of speeding tickets not get handled properly. And I think that is, because of a lack of kind of realization of what is at stake, what's going to happen based on how a ticket is resolved. So, but again, obviously different level of skill required when it comes to something as complicated and complex as the DWI arena is. I'm going to skip down to number 3, which says that another factor in determining whether a fee is clearly excessive is the fee that is customarily charged in the locality for similar services. So this kind of makes whether or not a fee is clearly excessive dependent on the locality. Skip down again to number 7, Rule 1.5A7, and in determining whether a fee is clearly excessive, the experience, reputation, and ability of the lawyer or lawyers performing the services also goes into that determination. And so those would be the 3 main things. Again, I do think for even criminal and DWI purposes, some of these other factors do come into play, but those are the 3 that I kind of wanted to specifically point out. So again, in determining whether a fee, not whether a fee is reasonable, not whether a fee is, market value, these are factors to determine if the fee is clearly excessive. That's what these factors look at. So again, in terms of prohibition, that is what you need to look at when it comes to determining if a fee is clearly excessive, which a lawyer is prohibited under Rule 1.5 from charging a clearly excessive fee. So now that we know what is prohibited, what are we, again, supposed to be charging? Well, this is dependent on a whole lot of factors. This is dependent. How do we set fees on a DWI case? Obviously, we don't want to violate the rules, but what is a fair fee? What is a fee that, you can say still is providing value to the client in the DWI arena? And I think that depends on a whole lot of different factors. It depends, again, on the ability of the lawyer, experience, knowledge about the specific practice area, what services are being rendered, how much time is going to be spent in court, how much time is going to be spent in research, what is being charged in that same location. And so we as a firm have offices throughout the state of North Carolina. And depending on the specific location, depending on the specific attorney that is involved in the case, currently our fees are anywhere between $2,500 and $5,000 on a district court DWI case. Start to finish, case goes to trial. That is the fee that we charge in district court. Again, depending on the location, attorney that's involved, and the specific type of case. That's kind of the general range of fees that we charge. But again, in terms of determining how to set a fee, I think that this is something that is really worth spending some time on and thinking about how do I go about setting my attorney fee on a criminal charge, and again, specifically with regards to a DWI case. So one of the things that I have always appreciated and loved since the first time that I saw it, and I repeat it regularly to our team, is that you, and this is from Jeffrey Gittimer. I think he's based out of Charlotte. He's written all kinds of books on sales and marketing and all kinds of different business oriented items. But he has repeatedly in his books and on his podcast and other places that I've read or seen him, he repeatedly says, compete on value, don't compete on price. Compete on value, don't compete on price. And so I think all too often when we talk to each other about our fees, when somebody has asked me about what do we charge on this? Another attorney has asked me about what do I charge? Or if a client calls in and their first question is, how much do you charge for a DWI case? What they're asking for is, what is your price point? How can I, kind of determine whether you're going to be, cheaper than this other person or more expensive than this other person? And that's the wrong approach. I can remember when I was about a year out of, it was probably even less than that, about less than a year out of practice. I was handling a criminal case, some sort of misdemeanor or traffic charge, and two attorneys walked up to me in the hallway and basically said, "Hey, let me run this hypothetical by you." And I knew these attorneys okay, but wasn't particularly close to them at this time. I was still pretty new in practice. They said, what would you charge if you had a client that had a felony possession with intent to sell and deliver marijuana? I'd never had a felony possession with intent to sell or deliver marijuana. So I was working for another attorney at the time. And I said, well, I don't know. So I'd probably just go ask my supervising attorney, see what he says. They're like, he's out of the office. Pretend he's not there. You got to set the fee right now. What would you set? And I kind of went based off of nothing. I said, I don't know, $750. And they both responded that they would charge, $2,000 for that fee. Now, I think that was kind of a feel out, is this new guy kind of in the same ballpark? Is he going to be undercutting us? Is he going to charge? So, I kind of, think that might have been where that conversation was going. But, I think that when we have conversations about fees, the question shouldn't just be, what do you charge for a DWI case? What do you charge for a speeding ticket? What do you charge for a misdemeanor possession of drug paraphernalia? That really shouldn't be the start of the conversation. The start of the conversation should be, if you have a client that comes into your office on a DWI, what are you doing for that client? What are the steps that you are taking to make sure that that client is prepared for court, ready to go? What are the steps that you are taking in the office to make sure that you are adequately defending that client on their charges, that you are being an advocate for them in the courtroom, defending them on the case, making sure that if there are triable issues, that these cases are getting tried, as long as that's what the client wants to do. Same thing when it comes to these conversations with a client on the phone. Anytime that a client, their first question is, what do you charge? That to me is a red flag. That's a red flag, because again, what they're trying to hire on price at that point. They're not trying to hire on value. My concern is to get the best possible outcome on a client's case. So the focus of what we are doing as me individually as an attorney, and the focus that I feel like we have at the firm, is to make sure that we are adequately representing clients, providing the absolute best value that we can. So I never start a conversation with a potential client about fees. Here's what we charge. Are you comfortable with that? Here's what my fee is. Let me know if you can pay that. Then we'll set up a consultation. No, that's backwards to me. The first thing that I want to do is get to understand the client's case, understand what they are facing, understand, was there an accident? Was there a blood draw? Do they have grossly aggravating factors? How long is it likely that this case is going to take in the courtroom? To me, without having all of that information, you can't set an adequate fee. And you certainly can't kind of figure out the value that you can provide on the case. So the fee is always the last thing that I discuss with clients. When a client calls in on the DWI and we have one of the staff answering the phone, if a client says, how much do you all charge for DWI? Our team basically says, hey, we'll set up a consultation with you, and the attorney that is speaking with you will discuss fees. We don't just spit back out here's what the fee is. It depends on the attorney, location, the complexity of the case, where this is happening. Are there grossly aggravating factors? Is this a case that could possibly be indicted as a felony? All these things are going to play into setting an adequate fee. And so I think all too often when we as a bar have a conversation about fees, we basically just want to have this mindset of competing on price. Am I in the same ballpark as this person when it comes to a price point, or am I not? Am I too far off? But the price point depends on the value that is getting provided. So in these conversations that we have with one another, other members of the bar, what we need to focus on is, what value are you providing to the client? What is it that you are doing? What is it that you as an attorney or your law firm is providing to the client that provides value to that client? And then once you've determined what the value is, then it's reasonable to ask, what do you charge for your services? Because one attorney's representation and model for handling a DWI case may look very, very different than another attorney or firm's model for handling a case. And the price point should be radically different depending on the value that is getting provided. If you're not providing the value, then the fee may not be reasonable. The fee may not be something that can be justified. You should be able to communicate to a client the value of your services. And again, that's what episode 64, why should I hire you? That's what that kind of relates to, is what is a reasonable fee. So first thing that I would say on this front is, when you are sitting down to kind of set fees, what should I charge for this? Begin with the end in mind. This is especially true for younger lawyers, newer attorneys in practice. Begin with the end in mind. When you have just hung up your law firm shingle, when you have just started your own practice, it becomes very easy to accept everything that is coming through the door. When you're charging a flat fee and that flat fee is paid up front, any amount of cash it may be kind of the live or die moment for your business as a young attorney. And so it can be very easy to say, look, I just need some cash flow in my business. And so really sitting down and thinking about, to adequately represent this client, how much time am I going to have to spend on getting up to speed in this practice area, in getting up to speed on this particular type of case? What am I going to need to do to make sure that I am able to be a bold and zealous advocate for my client in the courtroom? What is going to be the time length that this is going to go on for? If you've got a blood case where there is no alcohol, I mean, depending on where you are in the state and what each jurisdiction allows in terms of state continuances, I mean, you may be looking at 8, 12, 18, 24 months of representation, with multiple court dates, multiple times where you're checking in, just so that you can get the blood results back. And again, maybe getting the blood results back isn't the right option in every given case, or waiting for those to come back may not be the best option. Some jurisdictions may not continue that long, but these are factors for consideration in terms of how long am I going to be involved in this case. So take the time to sit down and think through what a adequate fee would be. Talk to other lawyers, talk to other attorneys about what their prep looks like on a DWI case, how long, given this particular fact pattern, they would expect the case to go on in the courtroom, what issues that you might be able to hammer out. Take advantage of your fellow members in the bar when it comes to workshopping cases. I've repeated that so many times on the podcast. The value of bouncing a case off of another attorney is so helpful, so incredibly helpful in terms of identifying issues that you might otherwise be blind to. It is something that I do on a regular basis with other attorneys at our firm and other attorneys in the legal community at large, is workshop cases and talk about, here's some issues to think about. So begin with the end in mind. Think about what the kind of time commitment and research commitment there is going to be to adequately represent your client in the courtroom to work towards getting the best possible outcome for your client. Number two, before you set any fees, before you think about setting fees, what is the value that you are providing to the client? If you are going to have a speeding ticket practice where you represent people with speeding tickets, before you start saying, here's what I'm going to charge for a speeding ticket, price should not be the starting point. First of all, list the value of having an attorney involved on a speeding ticket case, and then individually what value that you provide. Start with value. Always start with value. If you're looking at handling drug cases, if you're looking at handling larceny cases, felony work, DWIs, whatever it might be, what value am I providing to the client? And hopefully the longer that you're in practice, the more valuable that you become. Identifying your value in a specific practice area, a specific kind of charge that is something that you are advertising for or representing clients on. Start with value first. Once you've determined what your value is, then you can set the price, right? And obviously you're talking with other attorneys in the local area to see what other people are charging. But to set a reasonable fee, to make sure that you're providing value to the client, the start should always be, what is the value that I am bringing to the client? Why should the client hire me? Why does the client benefit from getting me involved in their case? Because if you can't answer that question, you shouldn't be getting involved. If you can't determine what the value is that you bring to the case, you should not be getting involved in that particular case, in that particular practice area. Another thing that to think about when setting fees is, how often do I reconsider the fees that I am charging? And the fees that I have charged on a DWI, when I first started practicing, I was charging $500 for a DWI. $500, that went up to $1,000 to $1,500, and now again, we're as a firm, depending again location, attorney involved, between $2,500 and $5,000 for district court level DWI. But how often are you increasing your fees? What should be the kind of checkpoint or tickler for doing that? A couple of things that go into that. When I first started practicing, fresh out of law school, I was not as valuable to a client as I am now. So in terms of setting a fee that was based on value, the value that I was bringing to clients in 2010 is different than the value that I'm bringing to clients in 2022. It's just a different value that the client is getting because of the education, the CLE that I've done, the individual research, all of the work that we've spent at the firm, workshopping cases, doing mock trials, all of that time and energy being in the courtroom, practicing, actually taking cases to trial, and in real time figuring out how these things can best be defended, how to adequately present all of the relevant factors in a sentencing hearing. All of that stuff is a huge part of the learning curve in any practice area. And again, I'd say specifically, since we're talking about DWI, the complex and complicated area of law that DWI is. So, you bring a different value based on the amount of time that you are involved in a case. And I would say this as well, just because you've been handling cases for 3 years, 5 years, 7 years, if you're not frequently trying to up your game, up your education, improve yourself as a lawyer in that particular practice area, then maybe your fee shouldn't be changing that much. If you're not, producing more value for the client based on your own education, based on your understanding of the complex and complicated area that DWI is, then maybe it's not something that there should be a big increase. If you are focused on growing as a lawyer and improving your practice, then that should be something that should be taken into account when you go to regularly assess whether the fees that you are charging correspond to the value that you are providing to the client. So again, as you increase your value, the price point increases. As you increase what you are bringing to the table, the value you're providing to the client, that price point increases, which again is why we should start these conversations with other lawyers about the value that we are bringing to the table. Secondly, just based on economics, things change over time. If you're charging $1,000 in 2002 for a misdemeanor paraphernalia case, and you're still charging $1,000 in 2022, you have discounted your fee to the client that is hiring you in 2022 versus 2002. Inflation is a part of this, and we've seen some massive inflation in our U.S. economy over recent months. But just based on a couple of different online inflation calculators, the value of $1,000 in 2002 is about $1,650 in 2022. So just even on kind of pure economics alone, the need to regularly assess fees, I think, is an important thing to think about. So how often are you sitting down to assess those fees, and what are the criteria if you're going to increase or change your fees? What are the criteria for doing that? What is the current economic situation? Has there been inflation, deflation? Has there been a increase in the value that you're providing to the client and the value that your team, your staff is providing to the client? That's the type of factors that should be thought through at any point where there is an increase or a potential change in the fees that you are charging for any specific type of case. So kind of to wrap up, or to kind of give a kind of final thought on this point, again, what I hope will be something that is less taboo and more talked about in our local bars is a conversation about legal fees. And that is not a pricing conversation primarily. I think where we can provide more value to the public, more value to the consumer, more value to the client is in identifying how each of us is handling specific types of case. What is the value that we are bringing to a specific charge? So as you, before you ask another lawyer what they charge, and I think that's a completely fine question to ask. I've talked about fees with numerous attorneys, how much they're charging. I've told people what we charge for DWI and for other type of criminal cases. Before you have a conversation about the price, ask first of all, what value is that attorney giving to their clients in a specific type of criminal charge? Now, don't make this a nasty question. It doesn't have to be something that is rude, like, hey, how come you charge it so much? What do you think you're special? I mean, you don't have to ask some sort of a rude question. So make sure you're phrasing it the right way. But I think if you present it to another attorney, hey, I noticed you handle a lot of speeding tickets. I noticed that you handle a lot of DWI cases. Tell me what you do for clients. What does your consultation look like? How are you preparing for court? What does your request for discovery process look like? How are you engaging with the client during the course of representation? How are you communicating with them? How are you preparing them for court? What are you telling them to do? Where are you sending them in terms of getting some services related to DWI? How do you get them ready for court? What are you doing in the courtroom the day of? Those are the questions where, as a defense bar, we can really elevate our game. Once we understand what great representation looks like, we can start to mirror that. The goal for us in providing better service to the public so that everybody gets great representation on a criminal case, on a DWI case, is for everybody to be bringing that A game in the courtroom. And the only way to do that is to understand, what does A game look like? What does great representation look like? And to get to that, you have to ask. So instead of it being a conversation that is primarily focused on price, which is what I will say I often kind of see in any kind of conversation between attorneys not of the same firm about fees, it's often about price. The conversation should center around value and the value that is being brought. And again, if price then is something that is talked about, fine. And I think it should be less taboo. But the real concern is, what is the value that me, the lawyer, is bringing to the client? If you can increase that value and understand what the value is that you're bringing, then you can set a reasonable fee. Look forward to speaking with you next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.